In a small-town courtroom, 17-year-old Ethan Carter stood before Judge Harlan Reed, his worn sneakers squeaking on the polished floor. The judge, known for his sharp tongue and impatience, smirked at the lanky teenager in an oversized hoodie, charged with a minor vandalism offense. "What's this, a high school prank gone wrong? You think you're clever, kid?" Reed taunted, expecting another routine case of youthful mischief. Little did he know, Ethan wasn't just a troubled teen. He was a legal prodigy, hiding a secret that would unravel the courtroom and leave the judge speechless. Ethan Carter's story began 2 years earlier, when he was just 15, living in the quiet town of Millwood. His father, a single parent and mechanic, worked long hours to keep their modest home running. Ethan's mother had passed away when he was young, leaving him with a voracious appetite for knowledge as a way to cope. He spent hours in the public library, devouring books on history, science, and, unexpectedly, law. Something about the structure of legal arguments, the precision of statutes, and the power of precedent captivated him. By 14, he was reading case law for fun, memorizing landmark Supreme Court decisions like other kids memorize song lyrics. One evening, Ethan stumbled across an online forum for legal enthusiasts. Using the pseudonym Lex Vero, he began answering complex legal questions posed by law students and even practicing attorneys. His responses were so precise, so well-cited, that forum users assumed he was a seasoned lawyer. Ethan never corrected them. He wasn't seeking fame, he just loved the challenge. Over months, his reputation grew, and Lex Vero became a minor legend in niche legal circles. But in Millwood, he remained just Ethan, the quiet kid who fixed his dad's old truck and kept to himself. The vandalism charge came unexpectedly. Ethan had been at the wrong place at the wrong time. A group of older teens had spray-painted graffiti on the side of a local warehouse, and when police arrived, Ethan was nearby, sketching in his notebook. The officers, eager to close the case, assumed he was involved. Ethan didn't protest much. He figured the truth would come out in court. Besides, he was curious about the legal process up close. He'd read about it, argued hypotheticals online, but never seen it unfold in person. This was his chance. On the day of his hearing, Ethan walked into the Millwood County Courthouse alone. His father couldn't take time off work, and Ethan insisted he could handle it. The courtroom was modest, with wooden benches and a faint smell of polish. Judge Harlan Reed, a 30-year veteran of the bench, presided with an air of authority. At 62, Reed was respected but feared for his biting sarcasm. He'd seen every excuse, every sob story, and had little patience for what he called kids wasting my time. As Ethan stood at the defendant's table, Reed leaned forward, his glasses glinting under the fluorescent lights. "Well, Mr. Carter," he said, drawing out the name mockingly, "care to explain why you thought defacing public property was a good use of your evening? Or are you just here to mumble apologies like every other delinquent?" Ethan didn't flinch. His voice was steady, almost too calm for a teenager. "Your Honor, I didn't commit the vandalism. I was sketching nearby when the incident occurred. I'd like to represent myself and request discovery of the evidence against me." A ripple of surprise passed through the courtroom. The prosecutor, a young woman named Claire Dawson, raised an eyebrow. Represent himself? Most teens barely understood their charges, let alone legal procedure. Judge Reed chuckled, leaning back in his chair. "Oh, you're a lawyer now? Watched a few episodes of some courtroom drama, have you? This isn't television, son. You're in over your head." Ethan's expression didn't change. "With respect, Your Honor, I have the right to self-representation under the Sixth Amendment, as affirmed in Florida v. California, 422 U.S. 806, 1975. I'm prepared to proceed." The courtroom went silent. Claire Dawson coughed, hiding a smile. Reed's smirk faded slightly, but he waved a hand dismissively. "Fine, kid. Play lawyer if you want. But don't cry when this blows up in your face. Ms. Dawson, proceed with the charges." Dawson outlined the case. Ethan was accused of spray-painting gang-related symbols on the warehouse, based on his proximity to the scene and a witness claiming to have seen a young male involved. The evidence was thin, but in a small town, that was often enough. Ethan listened intently, jotting notes on a legal pad he'd brought. When Dawson finished, Reed turned to him. "Your turn, counselor," he said, his tone dripping with mockery. "Impress us." Ethan stood straighter. "Your Honor, I move to suppress the witness statement under Rule 602 of the Federal Rules of Evidence. The witness lacks personal knowledge to identify me specifically, as the statement only describes a young male, which is insufficiently particularized. Furthermore, I request a Brady disclosure for any exculpatory evidence, including surveillance footage from the warehouse, which I believe exists based on public records of the property's security system." Dawson's pen froze mid-note. Reed's eyebrows shot up. The bailiff, a grizzled man named Tom, leaned forward in his seat. Ethan's language was precise, his citations accurate. This wasn't a kid parroting TV jargon. This was someone who knew the law. Reed recovered quickly, masking his surprise with a scoff. "You've got a mouth on you, I'll give you that. Motion denied for now. Ms. Dawson, you have anything to counter this performance?" Dawson, now visibly intrigued, stood. "Your Honor, the witness statement is admissible. It's corroborated by the defendant's presence at the scene. As for the footage, we're still obtaining it. The prosecution sees no basis for suppression at this stage." Ethan didn't hesitate. "Your Honor, if the prosecution hasn't yet obtained the footage, that supports my Brady request. Under Brady v. Maryland, 373 U.S. 83, 1963, the government must disclose material exculpatory evidence in its possession. Delay in providing it violates due process. I also move for a continuance until the footage is produced." Reed's jaw tightened. He wasn't used to being schooled, especially not by a teenager. "You're pushing it, Carter," he said, but his tone lacked its earlier bite. "I'll grant the continuance. Ms. Dawson, get that footage." Court's adjourned for 2 weeks. He banged his gavel, but his eyes lingered on Ethan, a mix of irritation and curiosity. Word of the hearing spread quickly through Millwood. By evening, Ethan's name was buzzing in diners and group chats. Who was this kid quoting Supreme Court cases? His father, bewildered but proud, grilled him over dinner. "Since when do you know all this law stuff?" he asked. Ethan shrugged, saying he'd picked it up from books. He didn't mention Lex Farrow or the years spent arguing law online. That was his secret, and he intended to keep it. Over the next 2 weeks, Ethan prepared relentlessly. He visited the library daily, cross-referencing rules of evidence and local ordinances. He also reached out to his online legal community, asking hypothetical questions about vandalism cases without revealing his situation. The responses helped him refine his strategy. Meanwhile, Claire Dawson, now wary of underestimating Ethan, dug deeper into the case. She found the warehouse footage, but it was grainy, showing only vague figures. Still, it didn't clearly implicate Ethan, which made her uneasy. When court reconvened, the atmosphere was different. Spectators filled the benches, drawn by rumors of the teen lawyer. Reed, sensing the attention, maintained his stern demeanor but avoided mocking Ethan outright. Dawson presented the footage, admitting it was inconclusive but arguing Ethan's presence at the scene was still damning. Ethan countered smoothly. "Your Honor, the footage fails to meet the preponderance standard under Rule 401. It's irrelevant without clear identification. I also call into question the chain of custody, as the prosecution hasn't provided documentation of how the footage was stored or accessed." Dawson scrambled to respond, but Ethan wasn't done. He called a surprise witness, Mrs. Lena Carter, no relation, a retired teacher who lived near the warehouse. Lena testified that she'd seen Ethan sketching that night, far from the graffiti site. Her testimony, combined with the weak footage, shifted the room's mood. Even Reed seemed to waver. Then Ethan played his trump card. He introduced a motion to dismiss, arguing the prosecution's case lacked probable cause from the start. He cited Illinois v. Gates for 162 U.S. 213, 1983, and dissected the police report's inconsistencies with surgical precision. The arrest was based on assumption, not evidence, he concluded. Continuing this case would be a miscarriage of justice. The courtroom was silent. Dawson, visibly rattled, offered a weak rebuttal. Reed stared at Ethan, his expression unreadable. Finally, he spoke. "Mr. Carter, I've been on this bench longer than you've been alive. I've seen a lot, but I'll admit, you're something else. Motion to dismiss is granted. Case closed." The gavel fell, and the room erupted in murmurs. As Ethan gathered his notes, Reed called him to the bench. "How do you learn all this?" he asked, his voice low. Ethan hesitated, then said simply, "I read a lot, Your Honor." Reed nodded, a rare hint of respect in his eyes. "Keep reading, kid. You've got a future." News of Ethan's victory spread beyond Millwood. A local reporter, tipped off by a spectator, wrote a story that went viral. Soon, law schools were calling, offering scholarships. Ethan's online alias, Lex Vero, was eventually linked to him, cementing his reputation as a prodigy. But for Ethan, the win wasn't about fame. It was about proving he could stand up, speak truth, and win on his own terms. Years later, Ethan would become one of the youngest attorneys to argue before the Supreme Court. But in that small-town courtroom, he was just a teenager with a secret, turning a judge's mockery into a moment of triumph.